I'm Joan Kaltzis. I'm a member of the Lake Forest Lake Bluff League of Women Voters, and I've been moderating forums in Lake County probably for over 30 years, so I thank you very much for coming this evening. I'm going to assume that we're all here for the same reason, which is to delve into the mysteries and the complexities of one of the state of Illinois' deepest and darkest financial holes. There certainly has been a strong voice heard throughout the state demanding an explanation of the failing pension system and as it exists within specifically the 5 public retirement systems for which the state has some responsibility. We know that not all public pension funds are flailing and woefully underfunded. The Illinois Municipal Retirement Fund, for instance, to which most of the employees of the city of Lake Forest and the village of Lake Bluff belong, is well funded and stable. So why the crises with the 5 funds for which the state bears some responsibility? Why is there so much verbiage, confusion, and fear out there? Our speakers tonight will both talk pensions. Our first speaker, Amanda Kass, will address the 5-pronged failing system, its problems, and how it got into such a catastrophic place, and what potential changes could be made. Then there's also the issue of the proposed constitutional amendment, which is on Tuesday's ballot. So what's that all about? Where did it come from and why? And what is it supposed to do? Our second speaker, Bob Riley, will address both the proposed constitutional amendment and constitutional implications to pension plans in general. And at the end of the evening, I would hope that we'd all leave here with more understanding and knowledge as informed and educated citizens and voters of Illinois. Our forum tonight is co-sponsored both by the AAUW, the American Association of University Women, and the League of Women Voters of Lake Forest, Lake Bluff. And as a plug for both of them, I'm asking maybe as you leave, you pick up some information on the table outside for the League. I know they have some, both the president of AAUW and what is vice president or whatever are out there. They'd certainly like to talk to you. And maybe you'd consider joining one of them. They both have women and men who are highly interesting and great people to meet. Now I need to add here that the League, which is always nonpartisan regarding candidates, we never endorse, oppose, or support any candidate or political party, but we do take positions on issues after we've studied them on national, state, or local levels. And in the interest of transparency, I need to state right off the bat that the League does have a position against the constitutional amendment, which is on Tuesday's ballot. Their position is based on the belief that any vote requiring more than a majority, in this case, the proposed amendment requires a proposed 3/5 vote, tends to place control of the issue in the hands of the minority rather than reflecting a majority position. The League also believes that the state constitution is not the place to place a provision that this is specific to a single issue, as the proposed amendment might make it. But we'll get to the amendment a bit later. And the amendment, as you'll know, is not the central problem here. 2 things while I think about it. Perhaps you could turn off or adjust anything that beats, buzzes, sings, or provides musical interludes. And we'll have time for questions which will be presented to the speakers via the cards that you've gotten as you came in or which are being passed out. We've got several people here passing out cards, roaming around. At any time, write out your question, hold it up, and they'll come and pick it up. And eventually it'll get up here and our speakers will answer the question. We'll ask as many questions as we have time for this evening, and we'll end about 9 o'clock. My job as moderator is to facilitate an open, respectful, and interesting evening. And of course, if this could be the case at home, it is the case with all public forums, the decisions of the moderator are final. So, not at home, but I have the privilege of introducing 2 of our presenters this evening. The first is Amanda Kass. Amanda is a research and policy specialist for the Center of Tax and Budget Accountability. She heads up the CTBA's Illinois Retirement Security Initiative. The center is a bipartisan 501c3 research and advocacy think tank that promotes fair, efficient, and progressive tax, spending, and economic policies. Their mission is to identify, develop, and introduce into the public debate rigorous, data-driven analysis and progressive, equitable public policy recommendations that will improve the fiscal health of Illinois and other states. So, ladies and gentlemen, I present to you Amanda Kass.
Hi, thank you so much for hosting me. Let me get this. Okay, so I'm going to just start out and go over some basics about the 5 state-sponsored retirement systems in Illinois. And then we're going to switch over to Bob, who's going to talk about the pension protection clause, and then back to me to talk about why the pension systems are so underfunded, why the state's pension contributions are a fiscal problem for the state, and then just kind of an overview about the major pension reform proposals that are on the table right now. So just to start out, there are 5 state-sponsored retirement systems in Illinois, and they are the Judges Retirement System, the Teachers Retirement System, the State Employees Retirement System, the State Employees Retirement System, and then the General Assembly's Retirement System. There's also other public pension systems in the state of Illinois, but these are the 5 state systems that the state is responsible for. So this slide is just showing you some demographic statistics about the 5 state retirement systems. One important thing to note is that the teachers' retirement system is the overwhelmingly largest retirement system. It has over 166,000 active members, and it makes up about 50% of the total membership of all 5 of the retirement systems. Some other things to point out is the number of retirees. And the number of retirees, that's only retirees. That doesn't include beneficiaries. So that doesn't include people who are getting a disability pension benefit or a survivor's pension benefit. It's only retirees. And then the third column is showing you the contribution rate. So that's the percentage of pay that each employee in each of the 5 retirement systems contributes for their public pension benefit. And for the state employees retirement system, there's 2 different rates there, 4% and 8%, because that's the only retirement system that's coordinated with Social Security. So if you're in SERS and you're coordinated with Social Security, your contribution rate is 4%. If you're not coordinated with Social Security, which means your only retirement income is going to be your state pension benefit, then your contribution rate is 8%. Another thing to point out is that out of all 5 of the systems, 80% of the members aren't coordinated with Social Security. There's only 20% of the total membership that will receive a Social Security benefit. And then you can see the average yearly pension and then the average years of service that that members have had before they retire. And then this slide is showing how a pension benefit is calculated. In general, the way a pension benefit is calculated is it's the number of years an individual has been employed multiplied by their final average salary. And the final average salary depends on which system you're in, times a multiplier. And so the chart is then showing you for each system what their multipliers are and what their final average salary calculation is. It's also showing you the number of the years of service and age at which a person has to have to be eligible for a full retirement benefit. So for the teacher's retirement system, for example, you have to be 62 years old with at least 5 years of service, or you can be 60 years old with 10 years of service to receive a full pension benefit. If you retire before these full pension benefit requirements, then you receive a reduced pension benefit. Then the next column is the vesting period. So those are the number of years required for an individual to have rights to a pension benefit. So for example, for the state university's retirement system, it was 5 years. And so if you were employed by the University of Illinois, for example, and you left before 5 years, so before you were vested, when you left the system, you would forfeit rights to a pension benefit, and you would be refunded your contributions for those 4 years, but you would not receive the contributions that the state had put in or the interest on your contributions for those 4 years. And then last, you can see the benefit limitation for each of the 5 retirement systems. So that's just kind of an overview of how the pension benefit is calculated. And one important thing to say is that this is how the pension benefit is calculated for those who are hired before January 1st, 2011. Anybody who is hired into one of these 5 systems on or after January 1st, 2011 is going to receive a reduced benefit, but they do have the same contribution rate. And I'll talk about that in a bit. For now, I will turn it over to the constitutionality.
Let me just say, thanks Amanda, that our next presenter, Bob Riley, comes to us from the law firm of Robbins Schwartz. Robbins Schwartz, as you probably know, is based primarily in Chicago. Bob is a partner of them, and his practice is concentrated in advising and representing units of local governments, corporations, insurers, and labor and employment matters. His areas of expertise include education, law, labor, and employment and litigation. So Bob, we welcome you. We're most interested in your insights into the law as it pertains to pension plans here that we're talking about tonight. Bob?
Good evening, ladies and gentlemen. My name is Bob Riley, and I am a partner with the law firm of Robbins Schwartz. I've been representing school districts, municipalities, and public entities since about 1989. I do quite a bit of collective bargaining on behalf of boards of education and colleges. By this I mean I represent public employers and help them negotiate collective bargaining agreements with public labor unions. So I'm involved in lots of discussions with unions like the Illinois Education Association, the IFT, the FLP, and I discuss with them things like wages and benefits, such as retirement benefits and insurance benefits, issues and benefits which have become the subject of serious reform efforts these past 3 or 4 years. I am not an expert in individual pension benefits. I know that some of you may have questions about whether or not something is eligible, something is not, how we calculate an individual or your individual benefit. I can't do that. What I'm going to be talking about today is the constitutionality of the kinds of reforms that are going to be discussed. As Amanda had mentioned, it's understandable that the state of Illinois is interested in pension reform. It's estimated that Illinois has at least $83 billion, and is that figure correct? At least $83 billion in unfunded pension liability due to the various state retirement systems. TRS is reported to be funded at a 46% level with an unfunded liability. I had heard it was about $43 or $44 billion. SURS is also underfunded and has an unfunded liability of about $17 or $18 billion. The amount of unfunded liability has real-world consequences for the state government. In January 2012, Moody's lowered Illinois' credit rating to A2, which is the lowest rating for any state in the United States. In that same month, Standard & Poor's lowered Illinois' credit rating from A+ to A, specifically citing as one of the reasons for doing so the $83 billion in unfunded liability. The A rating is the second lowest rating among the states, with only California being lower at A-. This impairs the state's ability to raise money by selling bonds, makes borrowing very expensive for the state. So what happens? Everybody says do something about it. Okay, but the question is what? What do we do about it? My talk this evening is going to center on the current constitutional impediments under the current state constitution to pension reform. First, I'm going to talk about Article 13, Section 5 of the Constitution of the State of Illinois. This should not take a long time because it consists of 1 sentence and 40 words. While lawyers wrote this sentence, which theoretically means it could go on forever, it is really stunningly brief by lawyer standards. Next, we're going to walk through a very simplified way of calculating a typical suburban public school teacher's pension. This is not representative of everybody. It makes some basic assumptions. I'm not going to complicate it with a lot of possible variants, like buying back years of service credit or variations in the service credit multiplier. We're just going to do a very vanilla calculation so we know kind of what we're talking about in terms of pension reform. Then we're going to discuss the legal arguments which say that it is unconstitutional under Article 13.5 of the state constitution to reduce pension benefits, and go over the legal arguments which say that such changes are in fact constitutional. After that, I'm going to turn it over to Amanda. If we have time later on, I will talk a little bit about the proposed amendment to the Illinois Constitution, which would make it more difficult for state and local governments to increase pensions or retirement benefits. Okay. What's the language that we're looking at? Article 13.5 of the Constitution of the State of Illinois says, membership in any pension or retirement system of the state, any unit of local government or school district, or in any agency or instrumentality thereof, shall be an enforceable contractual relationship, the benefits of which shall not be diminished or impaired. 40 words. In this case, however, brevity might not be the soul of clarity. There's a lot of ambiguity packed into these words. A couple of the terms are pretty clear. Membership in a pension system is an enforceable contractual relationship. What does that mean? Well, prior to 1970, which was the Constitutional Convention, pensions were not necessarily viewed by courts, public pensions were not viewed by courts as necessarily contractually enforceable promises. Some courts referred to them as quote-unquote gratuities. It's not exactly what you would leave as a tip at a restaurant, but there is that language in some cases, and it suggested that state and local governments could be able to nullify pension benefits almost at will. After 1970, employees now have a contractual right given constitutionally to pensions. What else does the amendment say? Well, it says membership is an enforceable enforceable contract, the benefits of which shall not be diminished or impaired. Well, here's the rub. What benefits cannot be diminished or impaired? Does it mean that anyone who enters upon public service is contractually guaranteed a pension based on whatever pension laws existed on the first day they were employed? Does it mean that an employee in public service is only entitled to whatever pension plan might be in effect on the very last day that they were employed? Or does it mean something in between? Well, the real debate is between the first and the last option. Is a public employee entitled to nothing less than whatever the pension plan provided on the first day of his or her employment? So if you worked at the DMV for 1 week, whatever the pension is on that day, you are guaranteed of getting nothing less than that when you retire 35 years later. Or can the legislature change the benefits, and if so, how can it change the benefits? I want to ask a question. How many people here are teachers or were teachers? It's the largest pension system. It makes perfect sense that we would have teachers. I want to walk through, and I know you're familiar with this, but so I can do in a little briefer than I had anticipated, but I want to walk through calculating a typical suburban teacher's pension. We need to understand how the pensions are calculated. This is a very simplified, the 2 points I want to make, this is a very simplified calculation. It doesn't take into account any elaborate or technical adjustments. We're not going to talk about how sick leave is used in determining service credit, or about early retirement options, or the reductions in benefits if you don't upgrade your years of service. None of that. This is just going to be a straightforward calculation. If you have questions about your particular circumstances, you should contact the applicable pension system or your union or a lawyer. That's not what we're going to be focusing on here. Okay, calculating the pension of a typical suburban teacher. Okay, it's basically a function of pay, years of service, and of a years of service multiplier or factor. First thing you have to do is determine the final average salary, FAS. Add the highest 4 consecutive salaries in the last 10 years, and then it says divide by 6. It should be divide by 4. It's not actually the last 4 years of service. It's the highest 4 years in your last 10 years. It is usually your last 4 years of service. So that's what we've done here. 2009, we're assuming this individual made $60,000. We gave this person 4% increases in 2010, 2011, 2012. You see those there, went from 60,000 to 62,400 to 64,896 to 67,491. Grand total of $254,788. We divided by 4. That gave us a number of $63,697. That was their final average salary, FAS. Okay, and that's the figure right there. These are the added numbers. That's the final average salary. Now we have to determine the years of service factor. For each year of service, we're giving the person a 2.2%, up to a maximum of 0.75. So if a teacher has 20 years of service, you multiply 2.2% by 20, they have 0.44 as the years of service factor. If a teacher has 35 years of service, it's 2.2% times 35 equals 0.77, but there's a maximum of 0.75 years of service credit. Okay. Multiply the FAS, the final average salaries, times the years of service factor. If a person retires at 20 years, again, remember a simplified version of this, multiply the 63,687 times 0.44, gives them $28,027. If they work for 35 years, the service factor is 0.75, remember that? So it's multiply 63,697 by 0.75, their annuity would be $47,773. This gets adjusted, there are various adjustments here, but that's the basic way you calculate a typical suburban teacher's annuity. Well, what if you change that service factor, that 2.2%, to something else? Say you changed it to 1%. Let's go to the next slide. Calculating the pension of a typical suburban teacher, effective reduction in years of service factor rate at the 20th year of service for a teacher who retires in 35 years. Say the legislature today says, okay, we're not going to change that 2.2% factor for anybody who, for prior years of service. But beginning in 2013, we're going to change the service factor from 2.2% to 1%. I'm not saying, it's not a proposal, but I'm giving you an example so we can understand this. Change the 2.2% for somebody who's worked for the school districts for 20 years down to 1%. So now for the next 15 years, their service factor isn't 2.2%, it's 1.0%. So how would you calculate their pension? You take the 20 years at 2.2% service factor, 0.44. 15 years at 1%, it's 0.15. 15, it should be plus 44 equals 0.59. 0.59 is the factor times 63,697 gives them $37,581. The difference is about $10,000 a year. If you reduce the service factor on a go-forward basis, you would affect the person's pension retirement or their pension annuity by about $10,000. No one argues that you can change the service factor or anything like it for individuals' service previously provided. No one says that you can change that 2.2% factor for anybody who was already retired. The question was, could you change, say, for instance, that service factor for the individual on a go-forward basis? Did everybody understand that? Okay. Okay. Well, there's two camps. I'm going to give you the first camp, and then I'm going to give you the first position. That the formula, changing the formula at which service benefits were calculated is not constitutional. First thing I'm going to do is I'm going to point out that the arguments that I'm going to give you were set out in some exchanges between former Illinois Appellate Court Judge Gino DeVito and John Fitzgerald. He had prepared a memo for Governor Pat Quinn, arguing that the changes in the formula for calculating service credit would be unconstitutional. In that memo, he argues that such changes would undoubtedly violate Article 13 of the Illinois Constitution. Also, back in 2010, Sidley and Austin, an extraordinarily competent, large, highly esteemed law firm, prepared a memo for the civic committee of the Commercial Club. Not surprisingly, in that memo, Sidley argued that the modifications would not violate the Illinois Constitution. Both Judge DeVito and Sidley and Austin's arguments are probably much more comprehensive and much better expressed than I could express them, but I'm going to give you a summary of what their arguments were. Okay. Let's look at the arguments as to why changing the service factor, even for future years, like I just described, would violate the Illinois Constitution. We're going to call this the unconstitutionalist's arguments. So if you're an unconstitutionalist, you say you can't change the pension system on a go-forward basis, it would be unconstitutional, would violate the pension clause of the Constitution. Unconstitutionalists argued that the plain text of Article 13, the history and the development of Article 13.5, and the case law from the Illinois Supreme Court make it clear that the changes would be unconstitutional. First, they say, look at the text. It specifically says, and the amendment says, that public employees who are members in the pension and retirement systems have an enforceable contract right. You can't reduce it or diminish it. The concept is that the pension clause says that any time after an employee has accepted employment, pension rights are fixed. The employee has, quote, embarked upon employment, close quote, and on that first day of employment, all those rights to all those benefits in the state or local pension plans become binding contractual rights. In support of that, they cite floor debates that occurred in 1970 when the Illinois Constitutional Convention was being held. And there is language that strongly supports it. Delegate Kinney was asked some questions about what the purpose of the of Article 13.5, the pension clause, would be. And what she says is, what it is designed to do, benefits not being diminished really refers to this situation. If a police officer accepted employment under a provision where he was entitled to retire at 2/3 of his salary after 20 years of service, that could not subsequently be changed to say he was entitled to only 1/3 of his salary after 30 years of service. The key words in that sentence from the floor debates is, if the police officer accepted employment under a provision where he was entitled to retire at 2/3. Her comments were that basically what the pension clause does is set the pension benefits at a floor that existed on the day the person, quote unquote, accepted employment. She goes on and says, it is simply to give them, public employees, a basic protection against abolishing their rights completely or changing the terms of their rights, quote, after they have embarked upon employment. Again, now there's not a lot on the floor debates about this issue, but she's quite clear about why the pension clause was being introduced in the Constitutional Convention and what its effect would be. If you start public employment, you have a contract right to whatever benefits are being extended via pension laws at that point in time. The people who argue and the forces that argue that the changes that I kind of suggested, the kinds of changes that I talked about, changing service factors, also say that 3 Illinois Supreme Court decisions handed down after 1970 support their position. They cite Peters, they cite Felt, they cite Buttle. Peters was handed down in 74, Felt in 85, Buttle in 87. Okay, I'm going to give you examples of what these cases look like. What happened in Peters? A city reduced the mandatory retirement age of its firefighters from 63 to 60 years of age. Dropped it down. 2 firefighters challenged the change, saying the municipality reduced their ability to max out on their pensions by 3 years. And when they did that, they said the general, remember, the longer you work, the bigger your pension is. The firefighters argued that they could have maxed out at 65% of their final salaries under the old program. They couldn't do it under the new program, and therefore their pension rights were impaired and diminished. The Supreme Court rejected that argument. They said there's not a tremendous amount of analysis in the decision, but the critical sentence of the opinion said, from our review of the constitutional debates and the authorities, we conclude that the purpose and intent of the constitutional provision was to ensure the pension rights of the public employees which had been earned, they used the word earned, should not be diminished or impaired, but that it was not intended and did not serve to prevent the defendant city from reducing the maximum retirement age, even though the reduction might affect the pensions which plaintiffs would have ultimately received. This is not a good case for the unconstitutionality argument. The unconstitutionalists say that it's essentially, now, the unconstitutionalists know this, the people that wanted to say that the change would be unconstitutional, so they say it's dicta. It wasn't essential to the decision of the court. I have to say that's not entirely true. The court really did have to decide whether a reduction in the mandatory retirement age did or did not violate the pension clause. But there is another thing to point out about the Peters decision. The decision and the statute had only a, quote, indirect effect on pensions. The central purpose of the statute wasn't really to work pension reform. The central purpose of the statute was to have firefighters who were getting older not work. They wanted to reduce the mandatory retirement age. It wasn't centered on a pension reform. So there is an argument that that's not, the Supreme Court under those circumstances wasn't really focusing on the pension benefits. It was focusing more on the question of whether or not mandatory retirement ages could be reduced. What's the next case? The Felt decision in '85. What did the legislature do? The legislature changed the way that judicial pensions were calculated. Under the old system, a judge's pension was calculated based on his or her salary on the last day in office. Under the new law, a judge's pension was based on her final year's average salary. Final year's average salary. So if a pay raise was given in the last year the judge was on the bench, the judge's pension would be slightly less under the new law, because you would be taking their entire year's salary as opposed to the high water mark on their last day. Judges sued, claiming that the new law violated Article 13 of the Illinois Constitution and also another constitutional provision that prohibits reductions in judicial compensation during terms of service. The Supreme Court ruled that the law violated both constitutional provisions. The court said that it appeared the legislature enacted the amendment because it was worried that the judicial retirement system was not adequately funded. Does that sound familiar? Mm-hmm. The court concluded that there wasn't much evidence of that. The court noted that there were no public hearings on the proposed amendment and concluded by saying the conclusion is to be drawn that the amendment severely impairs the retirement benefits of the plaintiffs and those similarly situated, and on the record here is not defensible as a reasonable exercise of the state's police powers. Okay, unconstitutionalists like this case for obvious reasons. They point out that this was a prospective change in the calculation of the judges' pensions, which means that the Supreme Court thinks that even prospective changes in the way public pensions are calculated are unconstitutional. You will be shocked to know that the other side disagrees with this interpretation. They say that the language of the opinion which invalidates the statute based on the pension clause was, in essence, dicta. It wasn't central to the decision of the case. They said that the holding of the case should have been based on the other constitutional provision dealing with not reducing a judge's compensation during the term of service. The people that the argument, or the constitutionalist argument, that say that uphold the changing of pensions on a go-forward basis, also point out that the court didn't say that changes in the calculation of pensions on a go-forward basis are, quote, per se invalid. They say that the language of the decision says that the record here is not defensible as a reasonable exercise in the state's police power, means that they were using a balancing test. And that's an important concept to lawyers. A balancing test means, they say, that the court was saying that the state didn't prove that there was a pension crisis to justify changing the pension formula, or which would justify the exercise of a reasonable exercise of the state's powers, but they might. It depends on how bad the emergency is. That's what the people who argue that changing on a go-forward basis would be constitutional. The third case, and then I'll be done, is Buttle. Here the state university system passed a law which in effect basically eliminated the right of an employee to buy back military service credit under service. They gave them a time period to buy it back, and if they didn't buy it back within in that period of time, they canceled it. Buttle was a military veteran who was hired by the SIU, Southern Illinois University, in 1969. At that time, the law allowed him and all vets to buy back years of military service. This means essentially that if they gave SURS some money for each year of military service, SURS would count that year as a year of employment for calculating the employee's pension. In 1970, the Constitutional Convention was convened. Article 13.5 is adopted. In 1974, SURS statutes and rules were changed to preclude employees from buying back their years of military service. Buttle sued in 1983. He tried to buy back his years of military service, and he said, when I started working, I could buy them back. The Constitutional Amendment was passed after I started working in 1969. The Constitutional Amendment fixed my pension rights as of 1970. They changed the law in 74. You can apply it to new hires. You can't apply it to me. The court agreed. Essentially, the court said that Buttle's right to buy back years of military service became a contractual right when Article 13.5 became law in 1970. So Another good case for the unconstitutionalists, the people saying that pension changes will be unconstitutional. What do the constitutionalists say about the Buttle decision? They say, well, of course it was unconstitutional, because it would have deprived Buttle of a benefit that he had already earned before the 1974 statute was passed. They said that under the old law, Buttle could have bought out his military service on the very first day he was employed. They're right, he could have done that. And that right, which he had on the very first day that he was employed, would have been diminished under the SURS change. They say that this is not a particularly remarkable case because it's not talking about changes prospectively, it's really talking about a retroactive change. Buttle had the right when he's, as of 1970, the law was changed in 74, you can't go back and deprive somebody of a statute or of a right under a pension system that you had already earned 4 years prior. Okay. Now, those are the arguments for why it's changing the pension system would be unconstitutional, even on a go-forward basis. What are the people who argue that reducing service credit factors for future years is constitutional? I've already touched on some of these arguments. The proponents of the constitutionality of such a change argue, you'll be surprised, plain language of the pension clause. They say that the text of the pension clause amendment says nothing about what benefits are not to be diminished or impaired. They point out that lots of changes to pension plans occur, like increasing from time to time employer and employee contributions. They point out that employers are perfectly permitted to reduce the work hours of employees, fire employees, pension rates or pension contributions are increased from time to time. If you can fire an employee, why can't you take the lesser act of prospectively reducing the years of service factor for their pensions? They argue that the floor debates at the Constitutional Convention were taken out of context, and that the entire purpose of the statute, or the entire purpose of the constitutional amendment, was to make clear that there was an enforceable contractual right, that pensions weren't mere gratuities, but it said nothing about whether or not you could change, say, the service factor on a go-forward basis for employees. They argue that the pension clause prevents retroactive changes to previously earned benefits, but not necessarily prevents the legislature from changing pension benefits, how pension benefits are calculated on a go-forward basis. They finally say, forget what Representative or Delegate Kinney was saying, her personal views on some or more of the constitutional amendments don't control. It's not just what one person says the pension clause meant when it was passed. You have to look at the historical context. As far as the cases are concerned, the Peters decision, the constitutionalists argue, was rightly decided. They said that basically it stands for the proposition that prospective pension benefits are perfectly legal to change. The Felt decision, as I mentioned, the constitutionalists say that the decision about the judicial pension should have rested entirely on another constitutional provision. They also say that there was no per se prohibition established by the court. They said, as I point out, the Felt court actually used a balancing test. Balancing tests matter. They say that this means that if the state has a good enough reason, maybe such as an $83 billion unfunded liability and being ranked 49th out of 50th states in creditworthiness, maybe that would be enough to tip the balancing test in favor of upholding a prospective change in the way you calculate pensions. And in Buttle, I've already told you, the constitutionalists say that doesn't mean anything. In that case, the legislature actually did try to change the retroactively a benefit. They argue one more thing. They argue principles of contract law. Oops. This thing. The constitutionalists say that the pension clause makes public pensions an enforceable contract right. Great. It's an enforceable contract right. But they say that if fundamental contract principles apply, state governments can change the way prospective pension benefits will be earned if, one, they announce the change substantially in advance of time. So in advance. So you have to tell everybody, hey, listen, we're changing the way that, say, 2.2% factor is going to be applied. We're going to reduce it to 1.5 or 1.8. And 2, they make it clear to the public employees that by continuing in their employment, the employees accept the modifications to the way the pensions will be calculated. What does this mean? The argument goes like this. Public employees in state and local governments basically have a contractual relationship. Each day somebody goes to work, they in essence agree to work in exchange for a promise by the employer to be paid and to receive whatever benefits they have been given by contract. 2, state and local governments, however, do not have an obligation to continue to employ any public employees. In other words, absent a collective bargaining agreement or a civil service law, the state or local government could fire any or all of its employees tomorrow. There is no guarantee of future employment, and if the state or local government fires an employee, the employee, again, has no pension rights other than those that have already vested. The state constitution does not diminish the public employer's right to change non-pension benefits up to and including pay and terminating employees. Third point, because the employee does not have a right to continued employment, a state or local government can announce ahead of time that it is changing the way it calculates service credit for years' work, say after 2013, and that the employee either agrees or not to these terms. The employer's agreement not to fire the employee is valid consideration to form a new contract for purposes of calculating pension benefits for years for 2013 and beyond. So the government tells you that you either take these or you're going to be fired after 2013. If the employee stays on the job, they're accepting the change in the benefits. The courts go through a lot of handbook cases. I'm not going to go into those now. The anti-constitutionalists, the people that feel that this would be unconstitutional, say that lots of employees like teachers, and many if not most of state and local government employees, already have the right under civil service laws or collective bargaining agreements not to be fired unilaterally. So the state or local government's promise not to fire them after, say, 2013 in exchange for them changing how their pension rights are going to be calculated would give them nothing. Their argument is, I already have the right not to be fired except for just cause or for a reduction in the force. And for a contract to be enforceable, there's got to be some valuable consideration. There has to be something given to the person, which means something of value has got to be given to the employee. And a promise not to fire a public employee unilaterally after a particular date is nothing of value because they already have that right. The tenure laws protect teachers. Collective bargaining agreements protect other employees. So the constitutionalists come back and say, if a public employee isn't protected by civil service laws, so she can't be fired without just cause, the state can still change the employee's pension prospectively if 1, it gives advance notice of the change, and 2, it gives the employees any other benefit, like a pay raise. And it makes it clear that the employees, by accepting the pay raise, are also accepting the change in which future years will count towards calculating their pensions. Okay? The unconstitutionalists say, well, then they really have no rights at all, right? I mean, if the whole idea is if you raise my salary by a penny, and that's good enough consideration to change my future, the calculation of my future pension benefits, what rights do I have? The unconstitutionalists say, well, you're fully vested, you're not vested, but the 2.2 calculation factor that was used for your years of service to date can't be changed. We agree with that. Okay. So those are the arguments. Any questions? No, kidding. What's the bottom line? Here's the bottom line, in my opinion. Both sides have strong arguments supporting their views. Both sides claim that the language and legislative history of the pension clause supports their position. Both sides claim the Illinois Supreme Court cases support their position, and if they don't, they should be disregarded. The constitutionalists also argue that fundamental principles of contract law apply to pension clause, the pension clause of the Illinois Constitution, and allows them to change the rate at which future benefits can be earned and accrued. And constitutionalists do not agree. The merits of these arguments. The case law, in fact, is pretty messy. As one of the participants in the Chicago teacher strike had said, it's a hot, buttery mess. Peters supports the constitutionalists, Felt hurts them, Buttle is somewhere in between. I would say the unconstitutionalists, those people who are saying that changing future benefits, or the way future benefits are calculated, have the better argument under the case law. Lower courts have held that the pension changes in the Peters decision were indirect changes. They changed the mandatory retirement age. They weren't really trying to strike at pension benefits. I think that courts would tend to read constitutional provisions expansively, and that there are other cases as well that suggest the pension clause might be read expansively as well. Another point, judges, I think on the Supreme Court, justices of the Supreme Court are honest, diligent, hardworking individuals that try to call the law as they see it, but they are in fact not 25 years of age generally. There's not a lot of lawyer or legal savants out there. It's not like math or chess or something like that. You're 50 or 60 years of age. And two, shockingly, they too are public servants. So I think there is some built-in sympathy, even if it may not be recognized by the Supreme Court, in favor of the employees. Now, it's one thing to say that a 20-year-old who goes to work at the DMV for a week, maybe you don't feel that it's entirely justified to say that whatever pension benefits are in place on that day, you must pay that person 35 years from now. But if you change the facts and say that somebody's been working for 25 years, and it's not so easy for them to change jobs or going to another area, then there is some force in terms of the equities to say maybe you can't change the pension benefits for somebody, even prospectively for the way you calculate the pension benefits on a go-forward basis under the pension clause. The problem is law is a blunt instrument. The law sees the kid that worked a week at the DMV just like the person that worked 20 years or 25 years for the inner city school system. Doesn't distinguish it. It's a blunt instrument. You can't be partially unconstitutional. The court's going to rule either one way or the other. The legislature, the history, and the floor debates also help the unconstitutionalists' argument, saying that this would be unconstitutional. Remember, upon accepting employment, the language that was used. And most importantly, I think that the politics strongly helps the unconstitutionalists, and that the odds are against that this sort of legislative fix. There's no ignoring the fact that Illinois is in a deep budget hole and that something needs to be done. I don't think the legislature wants to pass pension reform, which might be vulnerable to constitutional challenge, so that if a legislative fix were, so that they actually enacted a legislative fix, that it would be struck down. They don't want to do that. They want whatever they pass, they want to make sure that it at least has some semblance of addressing the dismal financial condition of the state. I do believe, for what it's worth, that the logic used by the proponents of the constitutionality of these changes, the arguments about contract law, does have merit, is persuasive, and is the better logical argument. I just don't think that the legislature is going to want to stake the future viability of the state's finances on something that could be overturned by the Supreme Court. The state's alternatives, and I went on for a while, but the state's alternatives are to enact pension legislation that doesn't fall prey to constitutional infirmities. Amanda's already touched on one of them, reducing the benefits for all employees hired after a particular date. There are other remedies that she's going to talk about, increasing contribution rates, shifting the costs basically from the state back to the local governments or the school districts, providing a legislative menu of choices to teachers and employees, so that even if you've got the gold-plated retirement program, you could, if you want, to pick another program if there was some consideration given for it, and Amanda will talk about that. There's some legislation limiting post-retirement double dipping, and some legislation dealing with COLAs, which probably would pass constitutional muster. Okay, that's all I have with respect to the constitutionality argument. I know that it was kind of a turgid presentation. There's a lot of law out there. Thank you very much. I'm going to turn the podium over to Amanda.
I just want to remind you that there are cards that are, if you don't have one, raise your hand and they'll be given to you. Write down any questions you have, because we'll be having a question and answer period after her. So, Amanda, are you ready?
Yeah, just the PowerPoint switched over again.
Ed, could you switch the video, please? And just, here's Carol. She's got cards if you need them, and she'll pick them up if you've written them out already.
was an excellent analysis of the pension protection clause that's in the state constitution. And kind of towards the end of my presentation, I'm going to go over the major pension reform legislation that's out there, and I'm not going to really weigh in on whether or not they're constitutional, but just talk about how they affect benefits and some of the cost savings that are generated. The main point I kind of want to get across in my presentation, though, is that the pension problem that the state faces, it really has nothing to do with benefits. It has to do with debt that the state owes to the pension systems and how the repayment of that debt has been structured over time. That's really at the heart of the problem. It isn't the benefits that have been earned or are being earned by current employees or retirees. So to start out, though, there's a couple of different things that with the state budget. There's the reasons why the pension contributions are kind of a fiscal pressure on the budget right now, and then also the past history of why pension systems are so underfunded. Just to start out, this is looking at the fiscal year 2013, which just started in July, looking at the overall general fund budget. So the first column is showing you, first row I should say, is showing you the projected revenue for the general fund budget for 2013. And it's, as you can see, about $33.7 billion. So that's the total kind of pool of money that can be used for general fund services. So that's things like education, higher education, public safety, all of that. The next line, though, is your hard costs. So your hard costs include your pension contributions, your debt service on obligation bonds, as well as statutory transfers. So that's about $9.3 billion. And then we have our deficit carry forward from our previous fiscal year. So from 2012, there's about $9 billion worth of unpaid bills that carries forward into this current fiscal year. So combined, that's about $18.5 billion worth of kind of costs, upfront costs, that need to be taken out of that $33.7 billion. So when you do that, then we're left with about $15.5 billion that's left for our general fund services. Again, that's K through 12 education, higher ed, public safety, healthcare, human services. So the fifth line, though, is the general fund service appropriations that were enacted for the 2013 budget. So at the end of May, the lawmakers in both the House and the Senate passed the appropriation bills, and what they came up with was the budget, which was $23.5 billion. So you have a general fund budget of $23.5 billion compared with your available revenue, which is only about $15.5. That then leaves us with our general fund, our minimum general fund deficit for 2013. So we kind of are starting out the year probably $8 billion in the hole. And our deficit at the end of the year for 2013 will then become our carry forward deficit for 2014. So why is this a significant problem? It's a problem because it's not just a one-year problem, it's a historic problem. So this is taking, though, if we looked at the 2012 budget and we projected out the revenue and the appropriations, just for accounting for population and inflation. So the blue line is showing you the appropriations. Again, that's for the general services, but also your hard costs, your pension contributions, debt service. So if we took that, that's the blue line, that's the appropriations. So we're not adding any services, we're not cutting services, we're just projecting it. Then you compare that with the revenue, which is the red line. And what we can see is that there's this ever-widening disjuncture between the money needed for appropriations, if we want to maintain our current services, versus the revenue that's going to be coming into the state based on our current tax system. Just one thing to point out is the dip that occurs between 2014 and 2015, that's because of the temporary tax increase. That's when it begins to expire. So that's why you see that dip. This has been a long-term problem, and what the state has done in the past, and probably will continue to do without changing the revenue side, is one, to cut services. So this is showing comparing the 2013 enacted budget with the 2000 budget. And so at CTVA, we took the 2000 budget and again just adjusted it for inflation and population increase, and then compared it with the 2013 budget. And when you do that, what you can see is that every major service category for the general fund has been cut significantly since 2000. So higher ed has been cut by about 40%, pre-K through 12 education cut by almost 12.5%, healthcare, human services, and public safety have all taken significant cuts. The other thing that the state historically has done, though, is to underfund the pension systems to cover the cost of these core services. So that then gets us to why are the pension systems so underfunded? Part of the reasons that they're so underfunded right now, as Bob mentioned, they have an unfunded liability collectively of about $83 billion. One of the reasons is because of this historic practice of underfunding the pension systems to cover the cost of services. Another reason has to do with legislation passed in 1994 or 1995. It's called, it's commonly referred to as the pension ramp or the 95 funding law, but it's Public Act 88-593. So just to give some background, why was that legislation needed at that time? Well, from 1989 to 1994, the unfunded liability for across the 5 systems grew by a little over $8 billion. In 1989, the unfunded liability was about $8 billion. So it almost doubled during this short time period, and by the end of fiscal year 1994, the unfunded liability was $17 billion. Again, today it's about 83. And then the 5 systems were about 54% funded. Today, collectively, they're about 43% funded. So the lawmakers were kind of looking at this at that time period, and as mentioned, there's a protection clause in the state constitution. So ostensibly, to rectify this underfunding, the lawmakers under Edgar's administration passed Public Act 88-593. However, it heavily backloaded how this $17 billion in unfunded liabilities was going to be repaid to the retirement systems. So what exactly did it do, the legislation? It did a couple of different things. The first one is that it mandated that the state's annual contribution to each of those 5 systems would be a continuing appropriation. So what this means is that in a given year, if lawmakers fail to pass an appropriation bill, the comptroller still has the authority to take money from the general fund and give it to the retirement systems. So it ensures that the retirement systems will get their yearly state contribution. The other thing that it did, the other 2 things, and this is really kind of at the heart of the problem, is the funding schedule that it put in place. It put in place a 50-year funding schedule. So the idea was that by the end of fiscal year 2045, well, for the 50-year funding plan, the state's contributions were to be sufficient so that by the end of fiscal year 2045, each of those 5 retirement systems would be 90% funded. Just to put this in perspective, so while collectively the retirement systems are 43% funded, the General Assembly's retirement system is only about 20% funded right now. So it has to get from right now in 2013, about 20% funded, up to 98% funded by the end of 2045. And then the other main part is that achieving this 90% funding target was done by implementing a 2-part funding structure. So while it's a 50-year plan, the first 15 years were what they refer to as a phase-in period. So in 1994, they knew that their contributions, the state's contributions, were insufficient, that they were underfunding the retirement systems. But rather than say, hey, this next year we're going to start properly funding the retirement systems, what they said is they realized that that would be too significant amount of money. It would take too much out of that general fund pool of money. So they said, rather than do this all in 1 year, we'll just do this phase-in period, and we'll incrementally increase our pension contributions year to year for 15 years, so that by the time we get to 2011, we'll have a relatively stable contribution rate from year to year. The problem is, several different things occurred during this 15-year time period that ballooned the problem further. So this slide is just showing you, in 1994, when they passed this legislation, this is what the pension ramp kind of looked like. This is what the state's yearly pension contributions looked like for that 50-year funding schedule. One thing that's really apparent is that this kind of repayment of debt is backloaded, right? It's not until the later years that the state's pension contributions are really significant and really begin to pay down the unfunded liability. This is the growth in the unfunded liabilities that occurred during that 15-year phase-in period. So from 1996 through 2010, the unfunded liabilities grew by about $57 billion. 44% of that is because of employer contributions. What that means is that the state's contributions were insufficient to cover both the cost of benefits being accrued by current employees and interest on the existing unfunded liabilities. Every year that a retirement system has an unfunded liability, that unfunded liability grows by the retirement system's investment rate assumption. So, and the state or the employer is responsible for that. So that figure right there, $24.7 billion, that's not even taking into account paying down the unfunded liability. That would just be paying the yearly interest, so it would just not grow the unfunded liability. The second major cause is the investment returns, and that's mainly because of the financial crisis from 2008. The third biggest reason is other factors. It's $10.6 billion. And other factors and changes in assumptions have to do with the actuarial information. So if termination rates, if the actuary's termination rates aren't in line with what's actually happening with teachers, that causes an unfunded liability growth in the other factor category. And then if actuaries change their assumptions, so the teachers' retirement system, for example, they just lowered their investment rate assumption. When they lowered their investment rate assumption, that increased the unfunded liability. So that's what those two categories are. And then you can see salary increases and benefit increases and how those have contributed to the growth in the unfunded liability. One thing to mention also is that the growth that the unfunded liability, the original one, is $17 billion. 55% of that was because of insufficient state contributions. So when you take that unfunded liability and you take the growth together during this time period, over half of the unfunded liability that currently exists, that $83 billion, is because of insufficient state contributions. So just some other things that kind of happened during the 15-year phase-in period. Some of the major ones were the pension obligation bond sales. So in 2003, under Rod Blagojevich's administration, $10 billion worth of pension obligation bonds were sold, and $7.3 billion worth of that went to the 5 retirement systems to pay down their unfunded liabilities. The idea at the time was that they were going to capitalize on historically low interest rates, and so they were going to have these pension obligation bonds, pay down some of the unfunded liabilities, which would slow the future growth in the unfunded liabilities, and create some savings for the state in the future. One of the problems, though, with this is that with the financial crisis of 2008, kind of the rules that made this a good idea or made it seem like a good idea at the time no longer occurred. So the savings that were supposed to happen with that $10 billion pension obligation bond sale really didn't happen. And then in 2010 and 2011, much smaller pension obligation bond sales took place. And those pension obligation bond sales, they weren't additional money to pay down the unfunded liability. The state just did it so that it could meet its pension contribution requirement based on the pension ramp. So what this meant was that in 2012, the state's pension contribution was going to have to actually come out of the general fund. So for 2010 and 2011, the general fund wasn't affected by the state's pension contributions. But starting in 2012 and then this year again, the general fund is affected. So then also during Blagojevich's administration, lawmakers passed legislation that underfunded the pension systems for 2005 and 2007. It was referred to as kind of the pension holiday. And so what they did is that for those 2 years, they underfunded the 5 pension systems together by about $1 billion each year. This is a significant problem because the pension ramp, remember, you're already in that 15-year phase-in period in which the state was still by law underfunding the pension systems. So this just underfunded them an additional $1 billion each year. The problem also, though, is that that 90% funding target isn't changed. So while you're saving yourself some money in these 2 years, you're creating future pain because you have to make these underfunding, you have to make up this underfunding in your next subsequent year. So it meant that the 2008 contribution was going to have to be a significant increase relative to the 2007 contribution. Also bad timing because 2008, then the financial crisis happened and the retirement system's investments were decimated. So that's kind of all that what happened during the first 15-year phase-in period. So by 2010, collectively the retirement systems had an unfunded liability of about $76 billion. And the 2010 contribution was going to be about 50% more from the 2009 contribution. Again, the majority of that year-to-year increase has to do just with debt owed to the retirement systems, paying down that unfunded liability, not the benefits that were being accrued by current employees. So what lawmakers did then is they passed legislation to create this reduced benefit tier. It's commonly referred to as Tier 2. And the creation of Tier 2, it affects not just the 5 state pension systems, but it also affects the Illinois Municipal Retirement Fund. It also affects all of the local police and fire pension systems throughout the state. And so again, it's for anybody who's hired on or after January 1st, 2011. So it didn't affect any current employees or retirees at that time. And then you can see kind of the ways that the Tier 2 benefit is different from the Tier 1 benefit. One thing that's really important to point out though is that even though a teacher who's in Tier 2 has a significantly reduced pension benefit, they're still contributing 9.4% of their pay to their pension benefit. That's the same contribution rate as the Tier 1 individual. That's kind of a problem because the Tier 1 benefit for a teacher, for example, is about 30% more than the benefit for the Tier 2 individual. And what it means for the teachers in particular is that the Tier 2 teachers are actually over-contributing for their pension benefit. So what that means is that their contributions exceed the actual cost of their benefit. So they end up actually subsidizing the state's contributions towards paying down the unfunded liability. Just to show that, so this slide is just showing you the effect that the creation of Tier 2 had on the state's contributions to the teachers' retirement system. So the blue bar is showing you the state's annual contribution that goes towards the unfunded liabilities, goes towards paying them down. And then the red part of the bar is showing you the state's contribution that goes towards benefits being accrued by current employees. So what you can see is that this red bar, it actually goes down over time. So what this means is that for the state, the cost of current employees' pension benefits, it's actually decreasing over time right now. That's important because all of the legislation that's out there right now really focuses on pension benefits. It doesn't focus at all on the blue bar of this. And then what you can see is that in the outer years, the red bar actually becomes negative. And that's because at that time, the employee pool, so teachers are predominantly made up of Tier 2 individuals. So again, they're over-contributing for their benefit. So this is just showing you, comparing the state's pension contributions before and after all of this. So the blue line, again, is that 1994 projection. That's what the state's pension contributions looked like when they passed Public Act 88-593. And then the red line is showing you from 1996 through 2011 what actually occurred, and then the projections going forward. So again, the spike is because of that $10 billion pension obligation bond sale. Then you see the dip because of the pension holiday. And then in the later years, the red line is less than the blue line, and that's the effect that Tier 2 had on the state's pension contributions. So even though those savings aren't realized for decades from now, the state kind of banked those savings all at once when it created the second benefit tier. And in total, the creation of the reduced benefit tier is estimated to save the state about $100 billion. But that's in the aggregate, that's not kind of all at once. So that's kind of the legislative history of why the pension contributions are what they are, and also why they're so significantly underfunded. just kind of switching gears to look at some of the current pension reform proposals that are out there. This slide is just an overview of Governor Quinn's pension reform proposal. And there's been several different pieces of legislation and legislative amendments that are designed based on this. But this slide isn't tied to one particular piece of legislation. So the real kind of heart of the legislation, there's two real parts. One is this cost shift, but the other part has to do with changes to benefits for current employees and retirees. So under this proposal, current employees and retirees would have to choose between these two options. And this only affects those who are in Tier 1. Tier 2 is not affected by this part. So those that are in Tier 1, both retirees and current employees, they have to choose between one of two options. The first option is that you keep your 3% compounded cost of living adjustment. And in doing so, you lose access to the retiree healthcare programs managed by the central management systems. And then also, if you're currently employed, any of your future pension benefit, any of your future salary increases couldn't count towards your pension benefit. So what that would mean is that at the time that you said, I'm going to keep my 3% COLA, whatever your salary is, that's what your ultimate pension benefit would be based on. It wouldn't matter if you had 5 years, 10 years, 20 years left in your career. It would be whatever your salary is at the time that you made that decision. Option 2 then is to accept a reduced COLA, and it's the COLA that those in Tier 2 have, and it's the lesser of 1/2 the consumer price index, or 3%, and it's calculated as a simple interest, so it's not compounded. And it creates a significant lower benefit over time than the 3% compounded COLA. And in doing so, then you would keep access to the retiree healthcare program, and you would be able to have your future salary increases count towards your pension benefit. A couple of things to say about this, about the access to the retiree healthcare programs. The lawmakers, this past spring legislative session, they passed Senate Bill 1313, which changed retiree healthcare benefits for those who are in the state employees insurance program. So the people who are in the state employees insurance program are those that are in the judge's retirement system, the General Assembly's retirement system, the state employees retirement system, and the state university's retirement system, with the exception of people who are employed by a community college. So people who are teachers, which was, I think, the majority of you in the room, you all know you're not in that insurance program. You're in the teacher's retirement insurance program. And only 60%, of retired teachers actually participate in the teacher's retirement insurance program. So what Senate Bill 1313 did, though, is it said that for those that are in the state employees insurance program, it used to be that if you had at least 20 years of service when you were retired, you didn't pay a monthly premium on your health insurance. You paid deductibles and you paid co-pays, but you didn't pay a monthly deductible. What Senate Bill 1313 says is it eliminates that. It eliminates premium-free health insurance. And it says that going forward, you're going to have to pay something. You're going to have to pay a monthly fee for your health insurance. But it doesn't say exactly what you're going to pay, because the rates are going to be negotiated by CMS and are going to be based on your pension benefit in your years of service. And there can also change year to year. So kind of one of the problems in this choice is that you're only keeping access to the retiree healthcare programs. You're not locking in what you would pay for your health insurance. Then the other kind of major part is this cost shift. And so the proposal is that, well, the idea behind the proposal is that school districts, universities, and community colleges are really the employer for those that are in SURS and TRS. And so they should be responsible for the cost of their employees' pension benefits, because they're the ones who negotiate the contracts. So the idea is that you would shift the cost of benefits over to the school districts, universities, and community colleges. And there's been various proposals of how long that shift would take place and how much would be shifted over time. But that's the idea. And so with this first part, this kind of option, savings for the state are generated because you would reduce benefits for current employees and retirees. With the second part, with this cost shift, the state realizes savings, but not because benefits are reduced, but because the shift takes place. So just the burden of paying for current employees' pension benefit accruals is just shifted from the state onto a local unit of government. So with this proposal, it's really important to ask, well, what savings does it generate? Another thing to point out too is that it doesn't fundamentally redesign the pension ramp. So it doesn't redesign how the state's paying back the debt owed to the retirement systems. So this slide, I don't know if you can you see the red row at all? No, okay. So this slide is just showing the cost savings that the Governor's Office of Management and Budget put out based on the proposal. So the red line is the red row is just showing you under the current schedule, so from 2013 through 2045, the state's general fund contributions are going to total, it's estimated, $310 billion. The blue line is showing what the aggregate general fund contributions would be if half of all individuals accepted the reduced COLA option. So accepted that lesser of 1/2 CPI or 3%, and no cost shift happened. So if that occurred, the state would save about $66.5 billion, and then it's a net decline in the general fund contributions of about 25%. Then the green line is showing you if half of all individuals accepted that reduced COLA and a cost shift did take place. The cost shift saves the state about an extra $20 billion. So you can see kind of the aggregate cost savings. But again, how does the state's yearly pension contributions look? Well, it doesn't look significantly different from the current schedule. So the red line is showing you the current schedule. The blue line is if half take the reduced COLA, no cost shift. And then the green is half take the COLA and there is a cost shift. So what you can see is that even though these savings would possibly be realized, which they're kind of based on the assumption that half of all people would take a reduced COLA, which is, I think, an overly generous assumption. But if that happened, your pension contributions still grow significantly from year to year, and they grow to the point where they are about 20% of your total general fund revenue, even under these two different scenarios. So I think it leaves the question of whether or not this is really going to solve the pension problem the state faces, because in 2010, right, they created this second reduced benefit tier. It's estimated to save the state $100 billion, and here we are again in 2012 debating this kind of proposal that would affect current employees and retirees' benefits. Just to go over really quickly, one other proposal that's out there, it's by Representative Fortner, and it's House Bill 6204. And I don't have the same, I don't have the cost savings estimates, but just to go over it, because it's quite different from Governor Quinn's proposal. His plan does a couple of different things, and a couple of them we at CTV think is really great. So the first one is that he identifies a new revenue source for the state's pension contributions, specifically for paying down the unfunded liabilities. So what Representative Fortner's bill says that as you pay off the pension obligation bonds, so the ones that were done in 2003, 2010, 2011, right now that's a dedicated stream of revenue going to pay down those bonds. So what he said is, once you've paid off those bond series, rather than allowing that money to go back into general fund pool, just dedicate it towards paying down the pension system's unfunded liabilities. So in that way, it's a new revenue source because you're not affecting the overall general fund budget. And then the second thing that he does is he guarantees state contributions through binding language. And that aspect, that part, is one of the reasons why the Illinois Municipal Retirement Fund is a well-funded retirement system, because the IMRF board, it has the authority to get the yearly pension contributions from the local units of government, from the employer. The other thing that it would do is it would increase the funding goal from 90% to 100%, and the funding target would still stay at 2045. And the reason that you're able to achieve 100% funded funding goal is through reducing benefits for current employees. So that's what this slide is about. One way that Representative Fortner's bill differs from Governor Quinn's is that it does reduce benefits for current employees, but it does not affect current retirees at all, only current employees. So what it does is it creates a self-managed plan for all but the state university's retirement system. And that's because state universities one already has a self-managed plan. And the self-managed plan is just like it's like a 401k style retirement. And so what would happen is that a pension benefit limit would be put on what individuals could receive for a defined benefit for all current employees. So right now, those who are in Tier 2 have a pension benefit maximum. And so this would just say that for those in Tier 1, you're also going to have a pension benefit limitation now. But what his legislation also says is that any salary that's above that cap for your defined benefit will be used for your self-managed plan benefit. So in that way, it creates a modest benefit increase for those who are in Tier 2, because one of the problem right now is, right, that they're over-contributing for their pension benefit that they're getting. And then the other thing is that school districts, universities, and community colleges would be responsible only for contributing to their employees' self-managed plans. So this isn't the cost shift that the governor has proposed or that's in various pieces of legislation. It could mean that school districts, universities would be contributing some, but it would be directly tied to how they negotiated salaries for their employees. So I know that's kind of a lot. Just to kind of sum up major points that I kind of want everyone to walk away with. The first is that the state, it's really facing a debt problem. It just happens to be debt that's owed to the retirement systems and not anybody else. It's not a benefit problem. So, you know, you can change benefits some. Whether or not that's constitutional is a big question. But the savings that you generate from doing that really don't solve the problem, because the problem is really tied to the pension ramp. So really addressing that problem involves two things. One is that you need to redesign pension ramp. You have to redesign how you're paying down those unfunded liabilities. Because right now, the way it has been done is that it backloads the repayment. So your pension contributions are going to significantly increase year to year. So without redesigning that, you're not really getting at the heart of the problem. And then to be able to redesign it in an affordable way, you really need to kind of increase revenue. Otherwise, you're going to have to either significantly cut from other services or continue underfunding pension systems.
I don't know how you retain all that stuff in your head, but anyway. Thanks, Amanda. Do we have some questions, more questions, Carol? Thank you. Let's ask some questions here, open to both of you, whoever feels they want to respond. Can the state pay back the teachers whatever they contributed and write off the rest of the debt? Going forward, can the teachers be placed in Social Security and not in state pensions?
Is the question for new hires?
It doesn't say. Do teachers? No, it doesn't say. Anybody want to eliminate that question? Can the state pay back the teachers whatever they contributed and write off the rest of the debt? I would say from our audience, it's probably Tier 1, maybe.
Well, the problem, I guess the problem would be that the state would run into the same problem of that the pension contributions right now are a significant part of the overall general fund budget. So let's just say theoretically you were going to switch everybody into Social Security. Well, the state's going to have to put in a significant amount of money, or get a significant amount of money to the Fed to be able to do that, one. And then two, going forward, the state would be dictating the contributions that the state would have to give it. So on the one hand, that would be good because the state couldn't underfund benefits then. But on the other hand, I don't think that the state would do that because there would be this hammer for their contributions.
Ed, do you want the microphones placed closer to them, or are you picking that up?
Yeah, you could.
Could you just?
Are they on?
We hear.
They're on also.
We can hear. We can hear.
Well, this is being recorded for TV.
Okay.
Now it's on.
Oh, thanks. Okay. Do teachers pay state income tax on their pensions?
No.
And the reason being?
Well, the retirees don't. The retirees who are in the teachers' retirement system don't pay state income tax. But people who are employed pay state income tax.
And the reason the retirees don't?
By statute.
By statute. Okay. The teachers pension plan is not Social Security.
No.
It's what
No,
we
the only retirement system that's coordinated with Social Security, again, is out of the 5 state retirement systems, it's the state employees retirement system. The other 4 are not coordinated at all with Social Security. So there's over 300,000 people who are actively employed who are in those 5 retirement systems, and 80% do not have Social Security.
Okay, thank you. Is the 3% yearly pension raise set in stone?
Unless the COLA is actually built into the pension plan, so that I think that there is going to be a constitutional challenge if it was removed or changed forcibly, as opposed to providing, say, a tier 2 a benefit that was held out as an option for the employees, for the retirees.
Okay. Other states have made some reforms. How have they held up in court? And gives the example of Rhode Island, who must have had some constitutional language like Illinois.
Well, they don't all have constitutional language. They actually don't have they all don't have constitutional language like Illinois. Illinois was modeled on New York's pension clause, constitutional pension clause. It is somewhat different than the constitutional clauses in Michigan, Alaska, and Hawaii, which talk about benefits that have quote unquote accrued, which those courts have held means the only benefits that you actually are promised are the ones that are in place at the time you've retired. So, and I don't know, I'm sorry, I'm just not familiar with Rhode Island's pension scheme.
Okay. Let's say the pension obligations do get moved to local districts or towns. Doesn't that mean a change in the law? And then couldn't the town or district change the funding amount?
Well, so part of the problem, at least school districts, universities, and community colleges, part of their dislike of the cost shift is that it's still the General Assembly who's dictating what those pension benefits are. So while you've now kind of shifted the cost onto the school district, it's still up to the General Assembly to set how the pension benefit is calculated. The school district, it retains control over setting salary, but it wouldn't retain control over how the pension benefit is calculated. But one thing is that with tier 2, remember the cost of the benefits, it's decreasing over time. So depending on how a cost shift is modeled, it would have varying impacts on a school district. If they, let's say the General Assembly passed legislation that said, hey, we're just going to shift it all right now, that would be a significant financial hit for school districts. But if they said, hey, we're going to do this shift over 20, 25 years, the pain of that cost shift would diminish over time because the cost of the benefits is decreasing.
And I think some of the proposals were to do it quickly and then to spread it out over time. The timeframes that I heard that they were trying to, or at least contemplating shifting the what are they called, normal costs back to the school districts was either like in a 1 or 2 or 3 year period, or maybe an 8 or a 10-year period, with kind of an initial downstroke at the beginning and then 1%, 1%, 1% added over time. But the districts, I mean, since I represent school districts, I think have got to be given some lead time to be able to provide for making those payments. And of course, at least in the cow economies, you also have tax caps, which affect the ability of the school districts to raise funds and raise revenue.
And then so Governor Quinn's proposal was turned into various amendments for Senate Bill 1673, which was being debated at the end of the spring legislative session. One of the reasons it never kind of was brought to the full vote had to do with the cost shift, because Madigan's proposals, there was a bunch of them, and they each had different time periods for this cost shift. But then Leader Cross was proposing something different. His proposal was that if school districts, universities, if they gave a teacher a salary increase, any salary increase, during the time period when their final average salary is calculated, that the school district would be responsible for the pension contribution that related to that increase. Right now, school districts are responsible for salary increases above 6%. So he was just saying, take that 6% down to 0, which the cost shift model advocated, or in Madigan's amendments, is kind of knowable, but the just changing it from 6% to 0% would create, is not as easy to plan for school districts, I would say.
Just real briefly to follow up on that, I would hate to have to negotiate that contract too, because you would, generally the principle behind teacher salary schedules, as many of you know, is that the longer you teach, the more money you make. Then you would have anybody entering into theoretically their final 4 years of service, generally people who at the age of 50, you'd have to look long and hard and somehow come up with a scheme where you wouldn't give them pay increases, or if you did, the pay increases would have to be accounted for in terms of the pension consequences. It would be very difficult on the school district, in the units of local government.
Okay. It's my understanding that the state at any time can dip into or take the monies that are in the collected pensioners fund. Is this true? And is there any reason, any way of stopping this?
Well, I guess I would say yes and no. The state can't dip into the pension systems. Like, it can't go to TRS and just take, TRS's assets and use it. But what the state government can do through the General Assembly is the General Assembly can pass legislation that changes the state's pension contributions. Right now, the way that the state's pension contributions are calculated annually is based on that Public Act 88-593. So it's based on that funding target. And what happened in 2005 was that the General Assembly passed legislation to so that the state's contributions for 2006 and 2007 would be a fixed dollar amount. So it deviated from that funding schedule. So in theory, lawmakers could pass legislation anytime that they wanted to that said, we're gonna no longer adhere to this 90% funding target. And then in that way, it could reduce its contributions to the pension systems and then use that money for services. But it can't just take money, and the governor doesn't have kind of the authority just to choose to underfund the pension systems in a given year.
Okay. The Lake Forest Lake Bluff pension is in good shape, but we have little say in the formulas. From what I understand, is this true? And how does it work locally? I think it's IMRF, right?
It's the IMRF, the way that the pension benefits are calculated is again dictated by state statute. So the General Assembly again sets the rules for how pension benefits for those who are in IMRF or your local police or fire pension, it dictates that.
Why is IMRF working versus the 5 that we've seen here?
Well, the real heart of it has to do, one, with the IMRF doesn't have this kind of 90%, it never had this 50-year funding plan, but the real kind of part of the reason is that the employer for the IMRF is your local government. So it's your village or it's your city. It's not the state of Illinois. And the state of Illinois has underfunded the 5 pension systems. And then the General Assembly can change the legislation at any time for how the state's contributions are calculated. Versus with the IMRF, while the General Assembly has the authority to do that, it's a bit more difficult. And then in the state statute for the IMRF has the authority to sue a local unit of government if it doesn't contribute to its pension system. So if a city or a village said, well, we don't have the money, we're just not going to contribute this year, then the IMRF can sue them to get that. And the IMRF dictates, calculates what the employer's contribution needs to be. The local unit of government doesn't do that calculation.
It's basically pay as you go for IMRF, and the other pension systems have not been set up that way.
Bob, when was IMRF set up versus the 5-tiered pension we saw?
Excellent question. I'm sorry, I don't know.
Okay.
The big thing though, I don't know the dates, but the big thing is that the 5 state pension systems kind of from their very inception when they started were underfunded. The IMRF doesn't have this history of underfunding like the state's retirement systems have had. So you have this kind of history of underfunding with the state retirement systems coupled with the financial crisis. And that's why you get this real
problem that we have today.
Comment on recent horror stories where employees work in city government 30 years, then does 3 days of substitute teaching and qualifies for huge increases in teacher pension system. Does that make any sense?
Yeah, that was a piece of special legislation, I thought. That was a carve-out piece of legislation. I'm certain there was a question, though, yes. And
Well, I think it refers to somebody who gets a regular pension and then they work a little bit at some other job and walk away with a bonus here, so that's inordinate.
And I don't know, is there any reform proposed to fix those? I know that they actually passed something that was immediately on the heels of that coming out with respect. I thought it was a union official that wound up working.
Yeah. Yeah, they did. So part of the problem with the pension protection clause is the idea that, so if the General Assembly, let's say, carves out a part of the state statute that's gonna benefit, a handful of people and enable them to boost their pension benefit, if that legislation gets passed and then it's part of the pension code, then it becomes constitutionally protected. So even though it may be an egregious way to increase dramatically one's pension benefit, if it's passed and it's part of state statute, it becomes kind of constitutionally guaranteed. But what the legislation did a year ago is it did pass legislation to prevent these kinds of things in the future. So while the big cases that you heard about in the news, I think a year or so ago, it doesn't affect those individuals, it does affect individuals going forward.
Well, also some of the reform is, I guess, for SURS, for instance, that people who retire won't be permitted to come back and work for their employer if they earn more than, I think it's 40% of their wages that they were earning as a regular employees, and if they do, their pensions are suspended for that period of time. Or in other instances, tier 2 employees that shift from one pension system to another, and they retire from one pension system, go to work for another. The employer, I think, has got to pay the pension of the employee in the other pension system for as long as they're working for them. So there's a lot of provisions being put out there to discourage that type of double dipping.
Okay. Since teachers don't get Social Security or Medicare, which I don't know if that's true, and the state of Illinois is not morally responsible for pensions, why would a teacher want to teach in Illinois?
I think that's an excellent question. I think that's one of the real problems too, especially with the creation of Tier 2. And kind of one of the I think it's going to be a problem later down on the road, right? Like the state got to kind of bank these savings, and it gets to say to the credit rating agencies, look, we've done something, we've cut these pension benefits, but what's going to happen 10 years from now when people really realize how inferior the Tier 2 pension benefit is? But then also you have the problem at the kind of federal level of the reason the state of Illinois, the reason teachers don't participate in Social Security is because the state's pension benefit has to be at least equitable to Social Security. So if it turns out that the Tier 2 benefit is not at least equal to Social Security, then the state runs into a big problem.
Anything you want to say? Okay. This is probably more for you, Bob. What is the significance of the 3/5 requirement on the referendum?
Does everybody know about the 3/5 requirement?
Yeah.
Any type of improvement in the pension system passed at the state level has got to pass by 3/5. The governor vetoes and sends the pension improvement legislation back to the houses. The veto override, I think now it's by 2/3 that they would have to override the veto. Also at the local level, school districts, municipalities may not, with the term increase emoluments by any way, if it could have the effect of improving a pension benefit unless they get the 3/5 or vote of 3/5 of the board. Well, at the state level, I don't think it's going to have an immediate effect because I don't think there's any appetite on the part of the legislature to pass any kind of improvement for the pension programs anyway. I think the constitutional amendment, which was passed in the House and the Senate, the one that's on the ballot, passed by ridiculous majorities. I think there were single-digit no votes on it. So it's not going to have an immediate effect. But down the road, 10 years from now, if the pension systems turn around a little bit or the state's economy improves, then it would make it more difficult to pass any legislation that would basically improve the pension benefits. One thing that it might do, I was thinking about this, it might provide legislators with a political cover, so that if simply arguing that there is no political appetite now to their constituencies that want to improve pensions, simply arguing to them that, listen, that's not the prudent thing to do at this point in time, there's no political will to do that. They could also say, and it's not even feasible, because there's no way we're going to get 3/5 votes of both houses. So, you know, I'd love to help you, but I won't be able to look at the legislation. I mean, it could help out with that. In terms of the local school districts or other 7-person boards, usually, you know, how do these boards usually improve pension benefits or salaries? They do it by simply approving the collective bargaining agreement that's in place. Those votes, in my experience, not necessarily true everywhere, but most of those votes are 7-0, 6-0, 5-0, 6-1, 5-2. The 4-3 votes to approve a collective bargaining agreement are pretty rare, so I'm not even sure it would have an effect so much at the school district level. I will say there are some questions about what constitutes an improvement in salary. For instance, it includes things like bonuses, specifically, the constitutional amendment says bonuses or incentives. Well, you know, in another sector of the galaxy, the legislature has passed the Senate Bill 7 and PARA, the Performance Education Reform Act, which together try to establish that school districts have got to establish ways to evaluate teachers based on student growth models. Usually it's standardized tests or some type of test that have been developed. Well, there's now a lot of push to try to institute merit pay. Well, if you institute a merit pay program, will pay that's given on a merit pay basis be subject to the 3/5 majority? I'd say probably yes, the way it's worded. I'm not sure they meant that, but they meant to work that effect. But you know, that would be something I think that would that's going to happen. You're going to see merit pay proposals that, if adopted, got to pass by 3/5. And national board certification. For those who are familiar with that, a lot of times there are bonuses for national board certification. Those types of bonuses that would be implemented would also have to be passed by the local school districts by 3/5.
Okay. The proposed amendment has been seen by some as just a pretend move on the part of the legislature to be doing something substantial. Would you agree? Wade into that.
I'm going to be agnostic on this. I don't think it's going to have an immediate effect. I don't think it's going to come anywhere close to solving the dimensions of the problem.
Amanda?
I mean, I think a little bit it is meant to satisfy public sentiment for changing the pension benefits. Because part of it has to do with people who are in the private sector, right? They had their 401ks decimated by the financial crisis of 2008. The state, the state's budget is underfunded. You couple those two things together, and then you see people who have a guaranteed pension benefit. I think that creates kind of a general public feeling of like, well, why can't we do something about this? If our budget's underfunded, I lost my 401k. Why are you guaranteed to this? So I do think that some of it is meant to appease, or could be meant to appease the public, and then part of it could also be motivated by trying to appease the credit rating agencies, because it could show the credit rating agencies, look, the state of Illinois is being strong, it's doing stuff about its pension systems, don't downgrade us again, maybe you'll upgrade us, which does have an effect on the state's budget if we get downgraded or upgraded.
Okay, thank you. Can the state of Illinois file for bankruptcy?
I'm not a bankruptcy expert, but I know that cities can. I think there has been discussion about the filing for bankruptcy. I actually don't know.
Has any state ever done that?
No.
No.
Okay. The state of Illinois is broke. Why can't they change the Constitution?
Well, the Constitution has to pass by 3/5 of both aisles of the General Assembly, so both the House and the Senate, and then it has to be passed by the general public during a general election. So 2012 is our general election, and then the next one is 2014, right? So, you know, in theory, in 2014, something could be done to change the pension protection clause, but I'm not sure, you couldn't, even if you changed it, you couldn't retroactively change benefits, could you?
Yeah, I think there'd be an argument that even if you repealed Article 13.5, the pension clause, even if that could be done, there'd still be an argument that the rights under 13.5 had already vested. It's kind of the principle behind the amendment. And so you wind up essentially with the same arguments. The people that had been employed at that time were entitled to the full benefits and protections of Article 13.5 until they retired. I don't know how that would turn out. I mean, there's would be speculative.
So I'm looking at our audience tonight, in light of all that raised their hands as to those who have a history in the educational field, and they look like they're mostly retired. All that you said tonight, would that impact what these retirees are going to get in the future?
No, even though the retirement systems are significantly underfunded, and even though TRS is significantly underfunded, TRS has sufficient funds to pay out benefits to retirees for decades. I mean, it wouldn't, benefits really, paying out pension benefits wouldn't really be affected except for people who are young, who are relatively new in their career. It's not going to affect retirees at all.
Bob?
Yeah, no, I think that's right. I don't think the proposals are to change the retirees, but the current retirees benefits. Most of the proposals deal with trying to work some changes or offer some changes or a menu of changes for people who are currently employed.
Okay. Do either of you have any final thoughts that you'd like to throw out in another minute or so regarding what you've experienced this evening? Any pulse on what's out there and what's coming or what we need to know as informed voters or citizens? Bob, anything?
Well, actually, I was going to mention, my closing thought was dealing with the constitutional amendment. I'm not sure that, I kind of agree with Amanda. I think that there might be, it's being advanced in some respects, I think, to try to placate the credit agencies. I'm not sure it's going to work that much of a change in the actual operations of the local governments. I'm not sure that it's going to have any immediate effect on the state legislature. I don't think there's going to be even a majority that would vote for improving pension benefits at this point in time. If some of the changes that are being talked about are implemented, it might be interesting to see whether or not there's going to be constitutional challenges. Capping future salary increases from counting towards pension benefits, I think that would be something that would be looked at closely by the labor unions in terms of challenging that, because I think that looks an awful lot like some of the cases that we had discussed, the Felt decision, and looks an awful lot like the example that I had given, which was basically change the multiplier factor for future years of employment. But I guess we'll see what comes out of the legislature.
Okay, thanks, Bob. Amanda, any closing bits of wisdom?
I guess it's just kind of, let's wait and see what happens with the General Assembly. I do think that at some point in this next fiscal year, the General Assembly is probably going to pass some piece of pension reform legislation. I'm not sure if it's going to happen during the veto session or next spring legislative session, but I do think something will get passed, and I do think that lawsuits will probably get filed against it. So I do think they'll try to affect benefits for either just current employees or current employees and retirees. And then I would say also that I think all the legislation, well, at least all the legislation so far, again, it's just affecting benefits. It's not redesigning that pension ramp. So I would say that if something gets passed, it's upheld in the courts, and it reduces benefits, we're probably still going to be revisiting this issue in the next couple of years because the pension ramp is not redesigned.
Okay. Well, this is an end to our forum. I want to thank our two speakers here. They've been great. Thanks to the League League and to the AAUW for co-sponsoring this. I want to thank everyone for being here, for the people watching on TV whenever they see this. Is it tonight or is it later? Does anyone know?
On 17 and 19 in Lake Forest and Lake Bluff, various times throughout the week, and it'll be on YouTube tomorrow.
Okay. It'll be on later on and on YouTube tomorrow?
Yes.
Okay, well, if you've got any way of connecting to YouTube, if you're that with it, watch it. So, a few last pieces of information here. Election day is next Tuesday, as I'm sure you all know. Tomorrow and Saturday are the last days for early voting at the Lake Forest City Hall. Pick up some stuff for the league, that's my final plug. And most of all, I want you to remember that your vote is a cherished right and an awesome responsibility. So be safe in getting home, and good night.